Welcome to the Benefits Executive Roundtable, hosted by Dorothy Koshu, President of Advanced Benefit Consulting. Dorothy is a nationally recognized benefits and compliance consultant and group health broker. Here, you will watch and listen to industry experts who will break down the latest trends in employee benefits, healthcare reform, state and federal legislative and regulatory activities, all designed to empower executive decisions. We are proud to bring to you all new video podcasts. We hope that you enjoy your new video podcast format, and please forgive any audio or video imperfections. Thank you for viewing and listening. Meet Advanced Benefit Consulting, an award-winning boutique benefits broker and compliance consulting firm that offers comprehensive benefits and compliance consulting. We offer personalized service and the ability to work directly with the owners. We invite you to contact us or connect with us on LinkedIn and include us in your broker consultant search.
Welcome to the Benefits Executive Roundtable. I'm your host, Dorothy Koshu, President of Advanced Benefit Consulting. And I want to welcome back my guest today, Chris Condalucci, who is an ERISA attorney and also the Washington Legal Counsel for the Self-Insurance Institute of America, and also Anthony Murillo, who is the SIA Government Relations Manager. Welcome back, Chris. Welcome back, Anthony. This is beginning to be an annual thing with us, and I like it. So thanks for being with me today.
Yeah, we always have fun chatting with you and yucking it up, and there's never a dull moment. There's a lot of information to cover, and like you said, and we talked in advance of this, we could do this for 3 hours. We literally could,
and that's what I love having you guys here for, because you'll talk as much as you need to get the story told, which is great. And Anthony, welcome. Chris and I have been doing all the chattering here, so welcome. Thanks for being here.
No worries. Thanks for having me, Dorothy.
You're welcome. Well, let's just jump into this because there's so much going on. First off, let's start with a discussion on price transparency, compensation disclosure, and data sharing. Those three topics alone are huge, but then we're going to get into some more complex topics after that. So let's talk about the updates on these three things. Let's start with price transparency. When we recently spoke offline, you said that you were expecting some proposed regulations for improving and strengthening the transparency and coverage, the TIC rules. And regulations were supposed to be coming out any day now. And just for the purpose of our audience, so that you know and understand what's going on timing-wise, today we're actually recording this on October 1st, which was government shutdown day this morning, right? So Crystal and Anthony will be addressing this, but I want to just throw that out there right up front, that some of the things we may have been able to talk about, we might not be able to cover today. And that just means that we can do an update later if necessary. We can either add to this later on in the editing process and add some additional information on, or we can do a follow-up podcast after the fact. But I just want to start off by saying that right now we don't have regulations, but what might we see in those regulations?
Yeah, it's an excellent question. It's something that we at SIA have been talking about in our webinars and presentations that we give. And we've really been talking about this really since the day after the 2024 election. So we've been talking about what we could potentially see in regs, of which I'll touch on in a moment. So let me take a step back to say, by way of background, which the audience, I'm sure, is aware, the first Trump administration issued regulations increasing the public disclosure of medical prices and actually prescription drug prices on a machine-readable file that all payers, insurance carriers as well as self-insured health plans, must post, again, on a public website, the public disclosure. So now we're in the second Trump administration, and what we oftentimes call Transparency 2.0, based on our conversations right after the election, as I alluded to, as well as during the transition between November and January 21st, before the Trump administration became official, and from January 21st all the way up until today, which is October 1st, we at SIA and others have been talking to the transition team, existing Trump officials, Trump administration officials, on what could potentially be in those regs. So these regs, which will come out in proposed form, so they're not going to be final regs, but they're proposed regs to which then the public can comment on and ask the federal departments, the Trump administration, to modify whatever the proposal is, to fine-tune it, tweak it, scrap it, come up with a new idea. That's how the public comment process works.
Right.
But again, I'm leaving everybody in suspense on what do we expect to be in these regs. We do expect that the regs will improve and strengthen, as we refer to it, the existing transparency and coverage rule, the TIC rule, that once again, payers, insurance carriers, as well as self-insured plans must publicly post on a website. What we're expecting is increased penalties for non-compliance for both hospitals as well as payers. Now, I mentioned payers when it comes to this TIC rule. As most folks know, there's also a transparency regulation relating to hospitals, requiring hospitals to post medical prices on a public website. I'm going to push off hospitals for a moment and just focus on payers, considering we're self-insured plans and we are payers.
Right.
But I do expect there'll be increased penalties for non-compliance for payers, for self-insured plans and insurance carriers. Now, we also expect that there'll be an increase in audits of the machine-readable files that payers must publicly post, and that's both insurance carriers and self-insured plans. Now, a very important change that we're expecting to see, we're hoping to see, but I'm also expecting it to see, is that there will be a requirement that the CEO or an authorized representative of the insurance carrier, so let me just stick with insurance carrier, must attest to the accuracy of the pricing information and compliance with the transparency and coverage regulation. So an attestation requirement on the accuracy. Now, this is very important for self-insured plans. Why? Because the law says that the plan sponsor, the self-insured plan, is the one responsible for compliance. But many self-insured plans and plan sponsors rely on a service provider. In most cases, an insurance carrier-owned TPA that rents the provider network to the self-insured plan, and therefore it's that insurance carrier-owned TPA, that owner of the provider network, that negotiates the rates. Those negotiated rates need to be publicly disclosed on the machine-readable file. So 9 times out of 10, a self-insured plan sponsor is getting that information from an insurance carrier. And if there is an attestation requirement requiring the CEO or an authorized representative of the carrier to attest to the accuracy of the pricing information, that helps self-insured plans with their own compliance. Because I would argue that self-insured plan sponsors should feel comfortable with the fact that there is now kind of almost a liability being imposed on the insurance carrier to make sure that the information that they're providing to the self-insured plan, i.e. the negotiated rates, are indeed accurate, are indeed in compliance with the TIC rule. And that, again, we believe will go a long way with increasing the accuracy of the pricing information, as well as other aspects of complying with the TIC rule. The last couple things, because I know I talked a lot on what we're expecting in the reg, but I really wanted to hit that attestation requirement, is we're hoping that the federal departments, what we call standardize the machine-readable files, and that standardization is really just developing new fields, clarifying billing code types, service settings, charge classes, for example, facility versus physician, which are just important data points for payers, self-insured plan sponsors in particular, to know when it comes to the different type of settings, the different type of CPT codes associated with a particular medical item or service, as well as the service settings. Again, is it an on-site, hospital setting? Is it an off-site, outpatient setting? Oftentimes there's different prices associated with the setting depending on where that medical item is serviced. So that's going to be important and helpful. Also, making uniform the negotiated rates that are included in the payer file. So the TIC file that the insurance carrier and the self-insured plans are posting with the negotiated rate of the same payer in the hospital machine-readable file. I don't want to go too far in details, but there has been an interest of trying to make uniform the hospital transparency rules and the payer transparency rules. We do believe that there'll be an effort to make those rules a bit more uniform. And then lastly, trying to decrease the size of the machine-readable file. A lot of folks out there have been complaining that insurance carriers in particular, because they're, again, the owners of the provider network, they're populating these machine-readable files. Oftentimes, create files that are terabytes and gigabytes and, I'm not a tech guy, but just I've been told by data scientists how large these files are.
They're huge.
And the size of it is making it that much more difficult for anyone to try to consume the information, let alone analyze it. So we're hoping and we're expecting that we'll see some sort of efforts to decrease the size of the files. So that was a lot, Dorothy. I apologize for the long rendition there, but that's what we're expecting in some proposed regs.
Okay. Well, did you want to add anything to that, Anthony, or I think Chris pretty much covered it, but.
Yeah, Chris definitely did a great summary there. I don't really have much to add on the regulation, but I will add for your audience that in addition to all of us waiting for the regs, there actually has been some legislation introduced as well that would deal with a lot of the same policy goals. In the Senate, a bipartisan bill was brought forward by Roger Marshall and Senator Hickenlooper, a Republican from Kansas and a Democrat from Colorado, and it focuses on transparency and data sharing. The specifics in the bill, it would cover a lot of the same things. One of the things it would do, it would codify the hospital and tick rules, increase penalties and enforcement for compliance with those rules. As part of the codification, it would require separate and unique prescription drug MRF to disclose those prices. It would also do things like expand price disclosures for ambulatory surgical centers and lab imaging testing. In addition to a lot of the price transparency aspects, there also is some data sharing and gag clause provisions, which, as you mentioned, Dorothy, we'll get to a little bit later in the podcast. But like the regs, we expect this to move. It has bipartisan support, but we're not sure when. As with the regs, this government shutdown might affect the timeline. And depending on, how far the proposed regs go, it might, preempt some provisions of this bill. But if not, we do hope and we hear that this bill is likely to get some serious consideration and could be included in the end of the year healthcare package.
Okay, that's great.
And Dorothy, let me interrupt just to put a finer point on what Anthony said, then we can tie in your point about the government shutdown because it really is all related. Yeah. So oftentimes the federal departments, the administration, and Congress will kind of work in tandem, kind of contemporaneous tracks. But one entity might move faster than the other depending on, what's going on timing-wise, bandwidth-wise, just politics-wise. So again, we're expecting these proposed regs. And we expected them out really even today, October 1st, notwithstanding that today's the government shutdown, the official first day of the government shutdown. But we were expecting these proposed regs to be out October 1st. So if those regs came out, let's just say hypothetically, that could preempt the legislation that Anthony just mentioned. But at the same time, a lot of us like legislation. We like things in the statute as opposed to a reg. Right. So even though there might be some, again, we're using the word preempting because the reg might cover matters that the legislation is intended to cover, but it'll still be good to have the legislation enacted to codify and put those rules in the statute. But let's say, because we are in a government shutdown world, maybe we don't see those regs because it's October 1st. We haven't seen the regs yet. Depending on how long the government shutdown lasts, we may not see the regs for however long the government shutdown lasts.
Right.
It could last 4 months.
Right.
It could last 4 days, 4 months. Who knows? Could we see regs during the government shutdown? Maybe there are some government officials that are considered essential, and maybe those officials in HHS and the Department of Labor and Treasury who are responsible for this reg, and actually the Office of Management and Budget, who is also an entity, an organization that reviews these regs before they're released, are they going to be deemed essential? Maybe, maybe not. So could we see them? Maybe, but most likely not. But could Congress do something in November?
Right.
End of year. And then that legislation almost preempt these regs because the legislation happens before the regs.
Right.
So that was a lot of kind of chicken, egg, cart, horse.
Right.
But a lot of it is driven now by this government shutdown, which is, again, happening today. Who knows how long it's going to last. So when this is published on October 21st, maybe we're still talking about government shutdown. Maybe it's going to be over. Maybe we'll have legislation. Maybe we'll even have the transparency legislation enacted. We don't know, but the cool thing is...
Stranger things have happened, right?
But the cool thing is we know that all of this stuff is like right there.
Right.
It's almost finally in the law. It's just a matter of things to break our way.
Right. Well, my next question was going to actually be about, what about the changes for people like, employer plan sponsors, TPAs, brokers, consultants. But obviously, until the regs come out, we don't know that. But still, just in general terms, what sorts of things, how would that affect TPAs, plan sponsors, and brokers and consultants when those regs do come out?
We're going to talk about fiduciary issues a little bit later, but I'll just mention maybe saying it to the brokers and TPAs. Look, you all are responsible for helping plan sponsors be a better plan sponsor.
Right.
You have to help them keep their health plan costs low. And one way to do that is to help them obtain consumable information, for example, the pricing information. And I say consumable because right now there are some issues relating to whether the pricing information through these machine-readable files are consumable or not. But let's just assume they are. Try very hard to find consumable pricing information. Help your plan sponsor analyze and evaluate that pricing information, and that will help them be then better fiduciaries to keep health plan costs low. So if these regs do improve and strengthen the regs and these existing rules, that should make it easier for brokers and TPAs to help their plan sponsors. So that to me is the impact. And then to plan sponsors, it's like, look, you have a fiduciary duty to obtain and analyze this information. So then you, plan sponsor, should be on your broker and TPA. Sorry I'm being pointed here, but you, plan sponsor, should be on your broker and TPA and be like, dude, help a brother out. You've got to do this for me because I'm busy, making my widgets.
Right.
This is why I'm hiring you to help me.
Exactly.
So it's a two-way street.
Yeah, and that's how they show their value. That's how they show their value anyway. So
both have to be active here.
Yeah, if they're not showing their value, then they'll just look for somebody who is. So keep that in mind as well. Well, let's move on because another part of the CAA regulations actually was compensation disclosure, and we've talked about this before. You were also expecting proposed regs on compensation disclosure requirements in November, so that may still happen on time. We'll see. What do you think we might see in those regulations if and when they come?
Yeah, so we have been expecting those regs to come out in November. Government shutdown will impact that, of course. But to your question about what do we expect in these regs? Well, I think most folks know by now what the compensation disclosure requirements are because they were enacted back in 2021.
Right.
And most people out there, when I say people, practitioner attorneys like me, brokers and consultants like yourself, Dorothy, brokers and other service providers out there interpreted the law saying, oh, this compensation disclosure applies to brokers and consultants because that's what the statute says. So many brokers and consultants are furnishing these compensation disclosures to plan sponsors, so they're all doing the right thing. They're doing what the law says they're supposed to do. Well, in the statute that was enacted back in 2021, there's actually a list of services that the statute says if a service provider performs these services, you're subject to the compensation disclosure requirement.
Right.
Well, within those services are TPA services and PBM services. But TPAs and PBMs have taken the position of, no, the statute says brokers and consultants, so therefore we're not subject to the compensation disclosure requirement. Well, back in 2022, Congress wrote a letter to the Department of Labor, at the time the Biden administration, saying Congress always intended that if a TPA performed developing negotiated rates, record keeping, claims adjudication, if PBMs developed drug formularies, built provider networks for prescription drugs, and otherwise, you, TPA, and you, PBM, are subject to the compensation disclosure requirement. Well, the DOL back then did not act upon the congressional letter. Well, now fast forward to the Trump administration. The Trump administration saw that letter and said, Congress intended, for example, PBMs and, at least in the letter, TPAs to be subject to compensation disclosure. Well, at least with regard to PBMs, because the Trump administration and President Trump has been very vocal on PBM reforms, there was an executive order issued in May that actually said, DOL, you must issue regs clarifying that PBMs are subject to the compensation disclosure requirement. And that is what we expect to see in these proposed regulations that are supposed to come out on November, depending on government shutdown. We'll see. Query, though, whether TPAs will also be included in that clarification, in that proposed reg. And then lastly, will this proposed reg, this compensation disclosure, go further? Will it talk about fiduciary duties? Will it talk about certain contractual provisions that limit a plan sponsor's ability to satisfy their fiduciary duties? Is it compensation related? Is it not? That remains to be seen. So let's keep an eye out, and we're keeping an eye out for some unexpected or somewhat surprises they may show up in this reg, or it could be very limited.
Right.
Just to the PBM and maybe the TPAs.
So it's a stay tuned thing. Anthony, is there anything else you want to add to that?
Yeah, you guys are going to see this is a pretty common theme with DC, but there's also legislation that's dealing with the compensation disclosure. So, for instance, this legislation, it would aim to do a lot of the same goals as the regs. It would directly amend the 408B2 itself to include provisions that PBMs must disclose direct and indirect comp to the sponsor. It also, so to Chris's point, if we don't see in the regs, for example, the fiduciary requirements or TPA, clarification of TPAs that perform certain services, who needs to disclose, who doesn't, we could see those in the legislation. So if the regs contain all these provisions, it might preempt the legislation, make it kind of unnecessary. But even if, we expect the regs are definitely going to come out before this legislation, but if it doesn't go all the way and a lot of the provisions Chris mentioned, then there might, there likely will still be a push to get this legislation through. As we mentioned with the price transparency bill, it would be likely that we could see it in the end of the year larger healthcare package.
Okay, great. Well, let's move on to data sharing, which is also a huge topic. Accessing health claims data has been difficult at best. And as we talked about previously and offline, Congress, obviously, they enacted the gag clause prohibition with the CAA in 2021. And the owners of the provider networks are supposed to share good information, and they're still refusing to do that. Why don't you tell us about that? And also, what do you think the Department of Labor potentially could do in this area related to data sharing and, I guess, the lack thereof?
Yeah, and I'll let Anthony talk a little bit about the Department of Labor and what they may do, and I can maybe backfill some things. But the bottom line is, accessing claims data has been very difficult, to your point. We thought that the gag clause prohibition that was enacted in CAA 2021, which was effective February of 2021, would effectively get the owners of the provider network to share that information. But they've dug their heels in. They've made arguments like the agreement is between the plan and the owner of the provider network, not an agreement between the plan sponsor, the plan administrator, or the business associate. So as the owner provider network says, as we read the statute, we don't think that the gag clause prohibition applies here, and therefore we're not sharing the data. Or they do share the data, but they do put restrictions around it, limiting the use of the data, not being able to share it with like a data analytics firm, things like that. There is some merit to that type of argument, but I won't go down that rabbit hole. The bottom line is the owners of the provider network have been balking and digging their heels in. So what could happen? We're hopeful that this administration and this Congress, who both similarly are very interested in increasing access to claims data, does act. And maybe I'll turn it over to Anthony to answer that DOL as well as the legislative aspect to it, and then I could backfill maybe what Anthony says. So Anthony, why don't you hit on DOL and some legislation which we could see or couldn't see, but at least the Department of Labor and their interest here.
Yeah, thanks, Chris. Yeah, we know that data sharing is a huge focus for the DOL because the DOL Secretary, Lori Chavez-DeRemer, she's been a huge proponent of data sharing. Going back to her days in Congress, in fact, in the last Congress, she sponsored her own data sharing bill that was eventually rolled into the Lower Cost, More Transparency Act that passed the House. So since she's taken over the DOL, she's made it clear that this is going to be one of her top priorities. She is really focused on pursuing these goals from a regulatory standpoint. We do expect to see them issue more formal guidance clarifying what constitutes compliance, eventually start auditing plan sponsors and networks for violations. we do expect to see the DOL issue more formal guidance for things like increased enforcement, imposing penalties on the owner-provider networks that refuse to share complete and accurate data, increased accountability, like I mentioned, requiring authorized representatives from the owner-provider networks to attest that there are non-gag clauses in their contracts, and then extending the gag clause prohibition requirements to all agreements, like the NDAs and other agreements in which a group health plan may not be the contracting party. So those are just some things that we kind of expect to see in the regs coming out soon.
And I'm sorry, go ahead, Chris.
Yeah, and I would say, even to put a finer point, and maybe I'm stepping on your question. So, Saya, we have been advocating since the beginning. We advocated for the gag clause prohibition, and since then we've been advocating for clarifications. And so, again, to put a finer point on what Anthony just said, we're hopeful that, Chavez DeRemer was a former congresswoman, actually sponsored legislation to increase access to data in the context of audit. So we know that the existing DOL secretary is a proponent. So top down, we're hoping that has an impact. And we know that now with Daniel Aronowitz, who is the assistant secretary for the Employee Benefit Security Administration, EBSA, was recently and finally confirmed by the Senate. So Mr. Aronowitz is now at the Department of Labor, similarly a big proponent of data sharing. So we would expect to see guidance or regulations that would increase enforcement. So impose penalties on the owners of the provider network that are refusing to share a complete and accurate set of data, as Anthony mentioned. Increased accountability. I told you about the attestation requirement for the tick rule. We could very well see a similar attestation requirement in the data sharing context. And what do I mean by that? Because we know that there's an attestation already requirement on the plan sponsor attesting that there are no quote unquote gag clauses that is restricting the data. Well, here we would flip the script. We would put an attestation on the CEO or an authorized representative of the owner of that provider network. So the owner of the provider network, in the context of a self-insured plan, in coordination with the attestation from the plan sponsor, attests that there are no gag clauses in the contracts. And again, that goes back to the frustration that plan sponsors have been experiencing, which is, well, how can I attest if I don't know or if I actually think that there are restrictions?
Yeah.
And so if we could flip the script, we're hoping that helps plan sponsors in their anxiety, their ability to adhere to their fiduciary duties, and we're hopeful that we could see some guidance. That's not going to be coming out anytime soon, unlike the price transparency and the compensation disclosure, but we do expect efforts there.
Okay, great. Well, thank you for that. And I want to change gears just a little bit and shift to another very hot topic related to ERISA fiduciary duties. And you did mention this briefly earlier, but let's talk about this. Obviously, employee participant lawsuits have been increasing year over year here, and it's just been kind of frustrating and confusing for a lot of people. So there's a lot of things happening, which basically is forcing the employee benefits industry to take seriously those ERISA fiduciary duties, and so that they can better understand what plan sponsor duties are related to fiduciary actions. So I'm just going to stop there and let you guys talk about it, because Chris, I know this is a big topic for you. What's the latest on plan sponsor and employee participant lawsuits?
Yeah, and I'll first say, we at SIA have put together what we call a fiduciary must-dos document, where at a high level, we identify what plan sponsors should do to satisfy their fiduciary duties. Mm-hmm. These are just suggestions, not legal advice, but it's suggestions. And really, I'll go back to my pointing at the brokers and TPAs and consultants out there, like, access that information, whether it's size information or other information. Right. You really have to help your plan sponsors be better fiduciaries. And there is information out there and ways to help them. But a lot of this, why SIA put these must-dos together and why everybody's focusing on fiduciary issues, it is largely driven by the employee participant lawsuits, where, as of last year, finally saw employee participants suing plan sponsors in the health plan context. We saw similar lawsuits in the early 2000s all the way up even today in the retirement context, mm-hmm. but it's almost a redux of what we're seeing in retirement now in health, but it's somewhat of a different argument because retirement and health are somewhat different. But the claims are the same, which is you plan sponsor acted imprudently by, for example, overpaying for a covered benefit or paying a service provider excessive fees. And no prudent fiduciary would pay, this service provider these fees. Or you were asleep at the switch, plan sponsor, and you have a duty to monitor the service provider to make sure that they are behaving correctly and not behaving badly. And we see many service providers behaving badly. And so that falls to the plan sponsor. And so these employee participants going after the plan sponsor saying you acted imprudently, again, is forcing the benefits industry to take more seriously fiduciary issues. Now, these employee participant lawsuits actually have been dismissed based on lack of standing. So on procedural grounds, not necessarily the actual merits, like did the plan sponsor act imprudently or not? The court never got to that. So without getting into like lawsuit litigation 101, it was on procedural grounds, not on the merits of the case. So query whether these lawsuits or these complaints will be refiled, recharacterized, and these plaintiffs can get over this procedural hurdle to then therefore get the court to rule on the merits. Or maybe the court will just say, hey, procedurally, there's no injury here, so no standing, but I'm still going to rule on the merits. That would be very helpful to all of us because we'll know where the guardrails are, the guidelines are, the red lines are, what we need to do. But the bottom line is we know what we need to do. Plan sponsors need to analyze the data, monitor their service providers, review their contracts, eliminate contracts that limit the plan sponsor's ability to satisfy their fiduciary duties. So those are all things that are flowing from these employee participant lawsuits.
Okay, well, let me just follow up with a question related basically on all of the things we've talked about so far. How does price transparency, compensation disclosure, and accessing claims data impact whether or not a plan sponsor is actually satisfying their fiduciary duties?
Excellent question. Now, this is my opinion, of course. This is
we wouldn't expect anything else.
Chris Gondolucci's opinion here, right? Like, not Saya, not anybody else's opinion. This is my opinion. As an ERISA attorney, because pricing information is available, it's not perfect, but it is available. And in some cases, a plan sponsor can get their claims data. Maybe it's not a complete and accurate set, but it's some claims data. But the fact that you can get this information, not perfect, but you can get it. I believe a prudent plan sponsor has a fiduciary duty to look at that information, analyze it, evaluate it, and act on it. And I'll kind of give it this example. Like, let's say, the internet was created at what point in time? Let's just say 25 years ago, 40 years ago, right? But let's say I was simply using an abacus to, decide things when I could have utilized the internet. Well, a prudent person would have utilized the internet and not worked on their abacus to make a particular decision. It's somewhat similar here, and maybe it's a bad analogy, but if that pricing and claims information is available, a prudent person would access it, right? So times change. Like, if times change, prudent people act with the changing of times,
right,
and the different type of information that is now available to you, relative to an abacus, to internet, to now pricing and claims information. So a prudent plan sponsor would access that information. And I think you have a fiduciary duty to do just that. And if you don't do it, I think you expose yourself to potential employee participant lawsuits.
I knew you'd get into this because you are an ERISA attorney. That's good. That was good information. But I want to continue on this discussion for just a moment. Plan service providers typically are not considered fiduciaries. For example, a TPA, they say, we're not fiduciaries. And they're not generally unless they do specific things. So I'm going to let you talk about this, things related to discretionary authority and so forth. But can you tell us what service providers need to do and what they need to know and what they need to be aware of so that they know for sure that they either are or are not acting as a fiduciary?
Dorothy, it's a great question, and it's a deep question. I know I've talked a lot, so I want to take more time on this particular question. But a service provider is typically not a fiduciary, as you pointed out. And why? Because a service provider, in many cases, if not most cases, does not have discretionary authority over how plan assets are spent. So that's one of the biggest things, how plan assets are spent. So a service provider can't decide, how plan assets are spent. Yes, they cost the plan money, and the plan sponsor pays the service provider to do certain functions that cost the plan money, but that's not the same thing as having discretionary authority over how plan assets are spent. The best example I can maybe give is in a claims adjudication context. If the claims adjudicator TPA decides that a claim is eligible to be paid in accordance with the terms of the plan or otherwise, if the claims TPA makes that eligibility determination, they've just then decided how plan assets should be spent. That's an example of where discretionary authority on plan assets arises. Now, in many cases, though, claims TPAs on an eligibility question defer to the plan sponsor. And the plan sponsor has that ultimate decision-making authority on eligibility. Well, that makes the claims TPA not a fiduciary because they didn't act with discretionary authority. So it's a little bit murky on that, but it comes down to decision-making authority. And in many cases, service providers are not. Well, there's a recent court case in the Sixth Circuit that Blue Cross Blue Shield of Michigan, I'll actually say it because it's in the court case. It's a public document, and the court has ruled, said Blue Cross Blue Shield of Michigan, as a TPA to self-insured plans, they were intentionally overpaying claims, then clawing back overpayments through a shared savings program, and built into that shared savings program was a percentage of compensation that Blue Cross Blue Shield of Michigan paid itself for clawing back those overpayments. And a court effectively said, the Sixth Circuit said, that Blue Cross Blue Shield of Michigan in that context was a fiduciary because they had discretionary authority over determining how much they were going to pay the provider, how much money they would claw back, and they being the TPA, determined how much compensation they were going to get paid. So that's an example in a convoluted way in this short me rambling very quickly of trying to illustrate how a service provider could have discretionary authority. And that's where it comes down, is the discretionary authority. And it's still a gray area. So service providers out there, you're not going to know whether you're a fiduciary or not. In many cases, you're not going to be. But make sure you are saying to yourself, am I making decisions on how the plan assets are being spent? That's the threshold question that service providers need to ask and try to understand.
Yeah, and if it walks like a duck, it talks like a duck, it looks like a duck, it's a duck. As far as the Department of Labor and others are concerned, generally speaking. Well, we're going to take a quick break right now for a short ad, but when we return, we're going to talk about surprise billing and the latest on the federal IDR portal. And that's a lot to talk about. We'll be right back.
Marilyn Monahan of the Monahan Law Office counsels employers and producers on compliance obligations under federal and state benefit and insurance laws. If you have questions about ERISA, COBRA, HIPAA, and the ACA, the Monahan Law Office will help you navigate the legal requirements that apply to you.
Welcome to eBen, your trusted partner in benefits administration for over 50 years. Programs include traditional self-funded plans, level-funded plans, HRA plans, and ACA compliant plans. Contact us today for more information at eban.com, 1-800-249-8440.
Okay, welcome back. Let's talk now about surprise billing. Surprise billing has become a bigger and bigger issue for healthcare payers because medical providers are continuing to abuse the federal IDR process by doing a lot of things, including, Chris, which you notified me about. I wasn't even aware of this until you told me about it. They're flooding the system with thousands of disputes, and many of which are not even eligible to be in the federal portal. And this is such a huge topic. I know we can talk about it forever, but let's focus on the biggest issues here. Let's break this down a little bit first for our audience as a bit of a review. First of all, what do the surprise billing rules do in general, in a nutshell, and what types of claims are involved here?
Yeah, and Anthony, let me take this first, and then I'm going to kick it to you just because it's the high level, like, nuts and bolts, what really is the process, what's the statute say. And there's a lot of work that we at SI have been doing with our coalition payer partners that Anthony's been the tip of the spear on. But just to answer your question, but a lot of folks might know is if there is an emergency out-of-network medical item or service that is furnished, or if there is an out-of-network provider at an in-network facility that furnishes a medical item or service, those claims are governed by the surprise billing rules and the protections that are under those surprise billing rules. And what are those protections? Well, it's effectively intending to protect the patient from any balanced bill. So effectively, the patient only pays a derivation, the median in-network rate in a particular geographic region. So they're not getting like overly high billed charges in that balanced bill. Instead, it's more of a negotiated rate that the patient is paying. But then what that does is that creates a battle between the payer and the provider over who's going to pay that delta between that, median negotiated rate and what the provider is saying you owe for this medical item or service. Well, then the system or the process requires the plan sponsor, the payer, and the provider to try to negotiate what that amount should ultimately be. Oftentimes, there's no resolution within that negotiation period. And then there's an IDR process, the federal IDR process, that allows the provider and the payer to go to a mediator, go to an arbitrator, and have the arbitrator decide whose offer for this particular medical item or service should be the one that is chosen. And then that arbitrator, that IDRE entity, the independent dispute resolution entity, will make a final determination, and then the payer has to pay what the final determination is. Right. That's really the process in a nutshell. So Anthony, I'll kick it to you to get a little more detail on policy and kind of how we're trying to advocate changes for a system that we are seeing as being abused by the providers.
Yeah, going back to a little overview, when it was initially enacted, the NSA was enacted to protect patients from surprise medical bills. And at first, it was a pretty payer-friendly law, but now the IDR process has become so skewed in favor of providers. Yeah. It's created major cost pressures for, as I'm sure your audience is aware, for our plans. Like I said, it wasn't like this. At first, it was pretty payer-friendly law, and then we've had a number of lawsuits that has turned it into a very provider-friendly situation. As Chris likes to say, it's a tail wagging the dog situation. So much so that at the latest data, it has providers winning 80% of the time. Yeah. Often awards are given 3 to 4.5 times the QPA or qualified payment amount. We've seen some cases as bad as like up to 900% in some cases. So it's gotten incredibly skewed. Yeah. Yeah, it's totally insane. So one of the ways us as a community, we've worked with a coalition and certain stakeholders that we've partnered with. And one of our coalitions is the Coalition Against Surprise Medical Billing. And through that, we've engaged with federal departments, legislators, and their staff, both in the last administration. We've worked with the transition team for this administration. Once all the department heads got confirmed, we'd worked with their offices. Over the course of last year, we've sent letters, had meetings, a number of different communication strategies to kind of get our story across. And through those communications, some of the things we asked for is that they mandate the IDRE for payers with all the relevant information needed to process the determinations, prevent ineligible claims from being entered into the federal portal, try to get at the just insane amount of volume that's going through the portal right now, to prohibit IDREs from issuing payment determinations on ineligible claims, requiring and enhancing training and oversight for the IDREs. And this is the IDR entities that are making these decisions. The bottom line is for our coalition is to keep the NSA aligned with its original purpose and protecting patients without this crazy runaway cost for plans and participants.
Yeah. Some of the decisions that you said, which we'll talk more about, are just insane. But why do you think, I think the three of us know the answer to this, but for the benefit of our audience, why do you think the providers are actually flooding this system, and what do you think their goal is?
Yeah, I think they're flooding the system to bog it down, to make it that much more difficult for these IDRE entities to make decisions. As we've discussed, Dorothy, there's only 13 IDRE entities in existence, and there's bandwidth issues. There is, in truth, limited compensation associated with making determinations. With
I certainly wouldn't do it. I mean, they don't pay enough money for anybody to want to do it. I can't believe they even have 13 of them. If you knew what they were being paid, you wouldn't even question why there's only 13 of them. Sorry.
No. I mean, it's an excellent point, because I don't want to point to it's not in anyone's financial interest to be an IDRE entity,
right.
But effectively it's not. And so if you are an IDR entity, you're churning and burning.
Yeah.
Because you want to get some ROI, and if you're getting such a lower reimbursement rate, I'll say it that way, you're churning and burning. And so in many cases, if you flood the zone with, for example, many ineligible claims, they fall through the cracks. They get right through, and we're seeing in the data. I mean, CMS, who is the government entity that enforces the surprise billing rules, is the one that's saying, look at the data, that there is a 25%, if not more, of the claims that are being funneled through the system are ineligible. And I would argue that's even higher, because CMS can't catch
I think it's higher.
all of those claims and review them to say, yes, this is ineligible, this is eligible. And I believe that that's largely the reason why. And then underpinning that is the providers never liked this median in-network rate benchmark.
Yeah.
Because the median network rate is going to be lower than any bill charges that an out-of-network provider is going to charge. And the provider said, well, wow, I've been charging these high bill charges, and now I've got to come down. That's going to mess with my ROI. Yeah. So they filed lawsuits to try to derail the process. They successfully, I'll go so far as to say, mangled the process. They mucked it up, such that this median in-network rate is really of no value, is really of no import when it comes to the IDRE entity determining whose offer do I pick. Do I pick the payer's offer? Do I pick the provider's offer? And the last thing I'll say, I also think the flooding of the zone goes to the fact of how the process works. It's a baseball arbitration.
Right.
We've talked about this. Baseball arbitration means the IDRE entity picks the payers or the providers, and that's it.
Yeah.
So let's say the payer comes in with a reasonable amount, or maybe even a lower amount than what should be for this particular medical item or service, and the provider comes in with a really high amount. The IDRE entity might say, well, wow, the payer came in really low, and that's not cool. That's not reasonable compensation. I have no other choice as an IDRE entity but to pick the provider's significantly inflated offer, because I can only pick one or the other. Right. That's it.
Well, and
that's
also,
how the process
and also what I'm seeing in the real world as somebody who deals with these things from time to time here, is that what I'm seeing is that the providers do a really good job of putting real quick summaries at the beginning, bullet points, real simple as to why their prices are so high, because of this specialty, because of this, because of that. And then they're putting the documentation behind it. Where what I'm seeing, what the plan sponsors and TPAs are doing, are they're putting 85 pages together of stuff, and it's just too much information for the arbiter to actually go through these, as you said, they don't have the time, they don't have the bandwidth, and they're not being paid enough. And so they're not summarizing it well enough in the beginning. So they don't have time to go through this. So they pick the other one only because it's the easiest one for them to see at a glance. Page 1 tells me what I need to know. I don't have to look at page 2 through 86, right? Is that what you guys are seeing? Because that's what I'm seeing in the real world.
Yeah, no, excellent points. So yes, that's what I'm seeing from other organizations that adjudicate these claims and are kind of the middle person between the payer and the federal government. The IDRE here, obviously they're dealing with the provider as well. And many of those organizations are putting those briefs together. And yes, to your point, that brief, it's almost like a legal brief, as opposed to a summary. And to your point, there's something to say about summarizing. Obviously, you have all the backup information, but there is something to say about that summary that is impacting. But I do think it also just comes back to the IDREs are churning and burning. They don't have, in some cases, the appropriate education, which goes back to what Anthony said about our coalition partners. We want increased accountability, increased education, increased certification requirements in that regard. But it's a mangled process, unfortunately. It's become a provider-friendly process, unfortunately. We've been screaming at the top of our lungs, actually, before we started our conversation here, our coalition, we just had a meeting with the White House saying, you've got to get some regulations out that the previous administration had been working on. You've got to fix this abuse. But unfortunately, there's so many other priorities in the healthcare space that we're almost shouting in the wind, but we're hopeful and we're trying to get some change.
Anthony, did you want to make a comment before I come to my next question?
I was just, one of the things, is trying to, not play to their ego a little bit, but remind them like, hey, you guys were the ones that signed this bill into law, and it's been taken so far from the original intent that you guys put in place. So that's been one of our key, arguments to try to get some attention to this.
Yeah. Well, I want to step back for just a moment, just because I think it's important also for the audience members to understand this as well. There is, as you mentioned briefly earlier, there is a negotiation period which happens before it goes into the IDR portal. But in my opinion, I mean, that's basically where you should try to negotiate, right? I mean, that's where you should try to do the job up front so that you don't have to go into the system. But what are you seeing there? Because what I'm seeing is that the providers are not really wanting to negotiate during that upfront period, because they want to force it into the portals because they have obviously the greater percentage to win inside the portal, the big numbers. Is that what you're seeing?
Yes, that's precisely right. So to even just quickly answer that question, the providers know, it's not even think, they know they have a better chance in IDR as opposed to open negotiation to get what they want.
Yeah, for sure. Well, let's talk about something that you guys mentioned to before, and you touched on it earlier. As you said, the medical providers are submitting offers to these IDREs, these entities, well in excess of the qualifying payment amount, and even well in excess of bill charges. So we all think that's insane. Anybody that knows this system thinks that's insane, but that's happening. And how can they do that? Please explain to our audience what's going on here, and if anything can be done to kind of stop this or slow it down or do something about this.
Yeah, the only way to slow it down or stop it is if Congress and or the federal departments stop it. Yeah. I mean, that's what it comes down to. It's unfortunate that I don't want to say this the wrong way or make it sound the wrong way, but we're relying on the government to stop this. And the government, has so many other priorities and issues. I mean, we have a government touches so much going on that we're not going to get any relief from the government, unfortunately, anytime soon. And so it's maddening. There's limited stuff that plan sponsors can do because, again, the providers have figured out that they can just run up their offer dollar-wise because they know that the IDRE has this and this to choose from. They're making those summarized arguments. They're flooding the zone. They know the IDREs are churning and burning. And so they're kind of taking a flyer on it, too. They're like, and also there's limited consequences for flooding the zone, for asking for these. So it's almost like throwing spaghetti against the wall. Yeah. Let's throw as much spaghetti against the wall, and if all of it sticks, then awesome for us. Yeah. If only some of it sticks, pretty good for us. Right. And we're not going to get in trouble for throwing it against the wall.
There's no penalty for them, as far as I'm aware of that. For them if they do that. I mean, so far they can get away with it, right?
Yeah. And I've never really been in a position, policy-wise or just law-wise, as an ERISA attorney, that there's never really been a solution from I mean, there is, but I don't know if we're ever going to get it from the government. Yeah. And the best thing to do is, and I've said this to you, Dorothy, is the best thing to do is you got to complain to the Department of Labor in the self-insured context, because the Department of Labor's jurisdiction, not necessarily CMS, but you hit them both. Complain. That's the best you can do. I know we're all busy people, and complaining and putting those emails together takes time, but that's the best recommendation that we have. And even people have asked, like, should there be grassroots efforts in trying to, sure, you could try to call your congressperson or try to get the departments. But that's what we're here for. And we're shouting in the wind with our payer partners, with insurance carriers who have deep pockets. Like they've got a significant lobby as well, sometimes even more so than the employer community. And we're beating our head against the wall, right, Anthony?
Yeah. And I'll just say, I mean, our biggest hope, I think, at least my personal opinion, is that it comes from regulatory side. I think we face more of an uphill battle from a legislative perspective, because there's a lot of, there's a doctor caucus in the Senate, and there's a lot more, I think, provider friendly attitudes. And that's not even so much because of the lobbying. As Chris said, a lot of our coalition partners have equally, strong lobbies. I think that's just more their personal background and their beliefs. So I think that is a little bit more of an uphill battle as we kind of keep our fingers.
Yeah, it's a be careful what you wish for when it comes to trying to get Congress to change, because the providers have the ear of many legislators. Mm-hmm. So to Anthony's point, I would agree that the best hope for us is the departments. And I'll say this, though, there are proposed regulations that the previous administration had developed that would, for example, formalize the open negotiation process. And formalize mean you go through the federal portal, similar to how you go through the IDRE process, but here it'd be through the open negotiation process, which is intended to try to get the providers and the payers to negotiate. And it actually gives the federal departments an ability to track what's going on, because right now the open negotiation process is the Wild Wild West, and we know it's not even happening because there's no tracking. So even if you track, will the government be able to enforce? Maybe, maybe not, based on what we're already seeing, and you're hearing us complain about how difficult it's been and how the inability of the government to change this. But those proposed regs could help.
Yeah.
We just don't know when we're going to see those regs.
Yeah. Again, you talked about this earlier. You both did. All three of us did. But with these, highly inflated offers that are coming in from the provider side, those can't be overturned in most circumstances, right? There are only a couple of situations when they can be overturned. Can you just confirm that for our audience so that they understand that?
Yes. So the statute says the only way it can be overturned is if the decision was made fraudulently or due to misrepresentation. And that's a very high bar. Like, you can make an argument that these inflated rates, like, that's misrepresentation, but it's a very high bar legally, and you got to go to court to overturn it. Now, the departments did come out with some technical assistance that said in certain error situations, a determination could be re-reviewed and potentially overturned. But these errors must be communicated by the IDRE entity to CMS. So the plan sponsor, let's say they identify the error, and one error is ineligible claims, which is the biggest problem in many cases here. So let's say a plan sponsor says this claim was ineligible. The plan sponsor has to go to the IDRE and says, hey, you made a determination here on an ineligible claim. And then you've got to get the IDRE entity to stop what they're doing, relook and say, oh, yeah, you're right. Man, sorry, I screwed up. And then the IDRE entity, the plan sponsor said, okay, now that you said you screwed up, you've got to go tell CMS that you screwed up. And then that starts the process of being able to re-review the determination. So I get why CMS tried to limit the complaints, let's say, or the petitioning of CMS on these errors by designating this to all go through the IDRE. But it's almost like trying to think of best analogy. It's almost like asking your kid when they told you a white lie to fix something, or just I'm not thinking the right analogy, but it's like, why ask the IDRE entity to fix their own error?
And then they have to point out that they made an error. And then they're worried about, well, am I going to get paid anyway? Because if it was an error and it was an ineligible claim, then they could say they're not going to pay me, and I just spent all this time on it, so I should get paid. So, I mean, there's all kinds of stuff going on there, I would think, from all sides of this. But I do want to, because we've talked about this before, and some of the mistakes, some of these errors can be things as simple as the plan sponsor never even knew the claim went into the portal because they sent it on purpose, probably, to an address that didn't exist, or a 10-year-old address, and they knew that they had moved or something like that. And it's like they couldn't even fight it because they didn't even know the claim exists. So only one side submitted, and they won, and they were huge amounts. That happened to one of my clients, and it's not a fun thing to have to explain to your client that this is what happened. So So hopefully when they do come up with some regulations on these sorts of things, if they'll take those into consideration and they'll say, hey, we have to have a process for these situations because it isn't right. It isn't fair because we all know it's not fair, but somebody has to get this across in Washington, obviously, so that Congress and the departments can do something about this. And I know we're running very short on time here. So let me just ask this. Chris, you had mentioned this to me before. There are situations in Congress, their original intent here is not being met. They're not doing what they were supposed to do in Congress. And they were supposed to decide between, as you mentioned before, the benchmark in-network rate and a geographic region and a reasonable compensation amount by the provider, which are not the bill charges. But with everything that's happening, I mean, are the federal departments or Congress, are they willing, do you think, to step in and deal with this? I mean, what is there a way to go forward with this? Is there a way to resolve this?
I don't think so anytime soon, because again of what we just stated, priorities, the departments and Congress, I'd say more so the departments than Congress, we've filled their ears with all of these problems through the coalition that Anthony mentioned and otherwise. So they are fully, and they even see it in the data, as they're seeing the providers winning 80% of the time, the high percentage of ineligible claims. Like, they know it's going on. They just can't, or it's not a priority to stop. And I know I'm kind of piling on and kind of almost denigrating the federal government. It's not intended that way, or being Debbie Downer that we're not going to get anything. But I keep going back to, I don't know when we're going to get something. I mean, like this error stuff, the intent, it's a great intent. Like, I liked when I first saw it. I was like, awesome. These are errors that are very common. So now we can redetermine. But then I was like, you got to go through the IDRE entity, who really is the tip of the spear here. Like, they're the ones who really almost created the error. They didn't catch it or otherwise. Right. So that doesn't make sense. So maybe that idea, though, gets carried forward in some sort of future regulations. So there's more teeth behind the error process, or it's formalized somehow. So there's glimpses of maybe some help, but I just don't see when that's going to happen. Yeah. That's the big problem.
Yeah. And this can happen in the self-insured world and the fully insured world, correct? But I mean, we only see it in we see it on the self-funded side.
Yeah, I mean, carriers are pushing just as hard as we are.
And that's what I was going to ask. Well, you'd think the big carriers, they have more money a lot of times. Yeah. You think that they would fight this because it's hurting them. You think that they would step up and try to be part of this fight. So let's hope that they decide to do that, right? And step up alongside the self-insurance industry, because they're both fighting the same battles here. Well, speaking of that, I know we're out of time here. So this is basically probably one of the biggest challenges that the Self-Insurance Institute of America has had in quite some time. So I want to just ask you, isn't this like the best? If people aren't members now, shouldn't they be? Because just if only for fighting this type of scenario, I guess I'm just trying to give you guys a great plug because you do so much work and I want to make sure people are aware of it. Isn't this like the best time ever to join SIA if you're not a member? Speaking as a member myself.
Yeah, it's power in numbers. I mean, it's power in numbers. And now you might be saying, well, Chris, you just told me that you can't do anything. Well, we're trying. I mean, that's the thing. And you're not going to find success unless you try. So you need to try. And it is power in numbers. There is a financial component to everything. And again, on this issue, like, we are partnering with our carrier, our insurance company payer partners in the payer space, as Anthony mentioned, through this coalition. And power numbers help us help you, help us work with our, in a certain case, it's strange bedfellows, like insurance companies and self-insured plans aren't always aligned, but here we are, and significantly so. And so power numbers, that's the best thing I can continue to say. And so please join, become a member. You can hang out with Anthony and me. We're fun people, as well as we provide good information. And you can hear me continue to talk a lot, which I know people have come to learn in past podcasts as well as this one. But we're here for you. Like, that's what SIA is all about.
Like usual, Chris pretty much captured it all. But I'll just say, I know we sound a little pessimistic on the surprise billing, but like you said, we're still trying to keep the ball moving forward. But on things like price transparency, data sharing, a number of different issues, we are really excited and optimistic about the next, few months and this Congress in general. So no matter what kind of the issue is, we're constantly trying to move the ball forward, and we do that as a community. So
Right.
by all means, we'd love to have you, if you're not already, join our SIA community. And as Chris finally said, we work for you. So
Yeah. And I just want to say a personal thank you to both of you guys, because you work so hard on this stuff. And for the audience out there, the fact that these guys are involved with every single issue that's going on, and they spend so many hours on every one of these things that we talked about today and so much more. So I just want to say personally, thank you very much for everything that you do and the contributions that you make to this industry, because I don't know what we would do without you. I really appreciate you. And I think most others that are involved, that anybody that knows what's going on and the impact that SIA has had on the community would say the same. Thank you very much for what you do. Truly appreciate that.
We appreciate that. And likewise.
Thank you. Well, obviously we're out of time, but before we go, how do people reach you if they need to reach you or want to reach you about something?
We each have SIA.org email addresses. Maybe you could put that in the show notes afterwards, but mine is just CONDELUCI, Condeluci CONDELUCI, and then Anthony.
amorello@SIA.org. I'm way better at answering emails than LinkedIn, so that is definitely the preference.
Okay. Good to know. Thank you very much. Well, this is a great discussion. This has been a great discussion, and I really, really, really appreciate your time. I know we got a little heated at times on some of these things and kind of went off on some tangents, but I think it was good information for everyone and a very necessary update overall. So as always, thank you very much for joining me today. And as we said at the beginning, this is October 1st when we're recording this, and if updates come out before this it actually airs on October 21st, we will try to get you an update, whether it be in the show notes or however we can do that timing wise and so forth. If not, I will happily invite you guys back later in the season, if necessary, if you're willing to do that, to come back and give us some additional updates as well. So again, thanks you guys. I really appreciate you.
Yeah, thanks for having us as always.
You're welcome. So for everyone out there, particularly our very loyal audience members, I want to say thank you very much for watching and listening every week. Please stay safe, stay healthy, and stay tuned for the next episode of the Benefits Executive Roundtable. Thanks, everyone.
Thanks for watching. Stay tuned for compliance tips, cost containment ideas, new trends, and decision-making tools. This podcast is produced by Advanced Benefit Consulting, Fullerton, California. All views expressed are those of the host or interviewees and not necessarily those of Advanced Benefit Consulting. Information contained herein should not be construed as legal advice. We always recommend that you consult with your legal counsel as situations do vary. Ms. Koshu can be reached at 714-693-9754 extension 102 or toll free at 866-658-3835. By email at dmkoshu@advancedbenefitconsulting.com or visit our website at advancedbenefitconsulting.com.